Hi, my name is Chen, and I am a faculty member in History and Asian Studies at the University of British Columbia in Vancouver. Thank you very much for joining our session tonight in Vancouver and I think in the morning over in Hong Kong and Asia. First of all, I want to say a few words of thank yous, and then I will very quickly turn to our speakers. I understand that this is a topic of great interest, and we are very fortunate to be able to assemble a very distinguished panel to speak on this, on the issue. So first of all, I want to acknowledge that even though at this moment, I am not located on campus at UBC, but the University of British Columbia is a sponsor for this event, and it is located in the unceded traditional territory of the Musqueam people. And we all are very fortunate to have an opportunity to work, to learn, to teach, and perhaps to do our little share to make the world perhaps a more just, more fair society. So we are grateful to do that. I also want to thank the various sponsoring units on campus to make this event possible. Apart from the Hong Kong Studies Initiative, the Department of Asian Studies, the Center for Legal Studies, and the Center for Chinese Research, our sponsoring units. I also want to thank my fellow coordinators and organizers and student helpers, Professor Yan and Justin and Michelle for helping us for this event. And of course, I want to thank our panelists to agree to be part of this discussion. I very much appreciate that. So let me very quickly explain the flow of this event. So we will do a fairly traditional format of a roundtable. Each speaker will have about 15 minutes to share their thoughts with us, and then we'll then open up for Q&As. So during the presentations, all the audience are welcome to use the chat function to comment on the topics under discussion. But if you would like to ask a question for the panelists to discuss at the end of their presentations, then please use the Q&A button. That is where we will collect your questions. So those are the two functions that you may want to familiarize yourself with. On top of the questions that we'll be collecting here, I have also collected some questions in advance. So I'll be also asking some of those questions as well. It all depends on how much time we have. We probably won't be able to get through all the questions asked. So I just want to ask for your patience and forbearance if we don't get to your questions. So I want to quickly introduce the speakers. Professor Albert Chen is a former dean of the Faculty of Law and now a chair professor of constitutional law at the University of Hong Kong. He is also a member of the Committee for the Basic Law of Hong Kong under the Standing Committee of the National People's Congress. In addition to publishing widely in the areas of constitutional law and legal philosophy, Professor Chen has also been an influential voice on a range of political and legal debates that have bedeviled Hong Kong, including, for example, those surrounding the 2014 decision by the Standing Committee of the NPC with regard to the election of the chief executive, the proposal by the Hong Kong government last year to amend the Fugitive Offenders Ordinance, otherwise known as the Extradition Bill, and of course, the proposed national security law for Hong Kong. Mr. Wilson Leung is a barrister at Temple Chambers in Hong Kong, specializing in commercial litigation and public law. Before turning to law, Mr. Leung studied philosophy at the London School of Economics and Political Science at MIT. Mr. Leung has been active in the pro-democracy movement in Hong Kong since the Umbrella Movement in 2014. Whether in his own capacity or as a spokesman for a group of like-minded legal professionals in Hong Kong, Mr. Leung has spoken up against the extradition bill last year and in favor of the Hong Kong Human Rights and Democracy Act that was passed by the US Congress in November 2019. My colleague, Professor Cheng, is an associate professor at the Peter Allard School of Law at the University of British Columbia. She has also taught at the School of Law at Tsinghua University in Beijing. Among Professor Cheng's teaching and research interests are comparative constitutionalism, judicial politics, freedom of information, and the basic laws of Hong Kong and Macau. From 2006 to 2007, Professor Cheng was seconded to the Committee for the Basic Law of Hong Kong under the Standing Committee of the NPC. Among Professor Cheng's publications are a number of journal articles specifically on the basic law of Hong Kong. Finally, and of course, last but not least, my colleague, Professor Pitman Potter. Professor Potter is a professor of law and director of Chinese legal studies at the Peter Allard School of Law, as well as a former director of the Institute of Asian Research at UBC. Professor Potter is a scholar of law in the People's Republic of China and Taiwan. His areas of focus include foreign trade and investment, dispute resolution, property law, contracts, business regulation, and human rights. Professor Potter has written and commented extensively on China's legal system and its records on human rights. So if we move on to, very briefly, the various guiding questions that I had set out for the roundtable. I won't go through them, but I did comment, let the speakers know that these questions are not meant to be bounded. They are welcome to comment on the proposed national security law as they see fit. So without further ado, may I turn to Professor Chen.
Thank you, Liu. It's an honor and pleasure for me to be able to participate in this seminar. Actually, I was originally scheduled to visit UBC this semester, but because of the pandemic, the visit was canceled. So it's good that now I'm able to participate in this event. So I'll speak briefly on two aspects of the subject today. First, I will talk about the background or the causes for the recent decision of the NPC on national security law in Hong Kong. And then I'll talk about some of the issues which we will have to address in the future, particularly if the law is to be drafted. What are the issues which will have to be considered, and the current debate in Hong Kong on these issues. So as for the background for this development, I think everybody knows that we have this anti-extradition bill movement in Hong Kong last year, and there was quite a lot of violence. There were protests directed against not only the Hong Kong government, but also against the Chinese government. There were episodes in which the liaison office of the Central People's Government in Hong Kong was besieged, and the national emblem in front of the building was defaced. And then there are several incidents of the national flag in Hong Kong and in various locations being torn down. And also we have Chinese capital business in Hong Kong, like Chinese banks and bookstores and so on, being targets of attack, physical attack. So all these incidents. Also, you know, we see many demonstrations in which tens or hundreds of American flags were raised. In fact, I've never seen so many facts in my life until last year. So all these actions, all these events, I think, contributed to the latest decision of the NPC. So my own view is that, but for the anti-extradition movement last year and what happened during the movement, there would not have been such a decision to introduce a national security law in Hong Kong. We all know that Article 23 of the Hong Kong Basic Law requires Hong Kong to enact laws on treason, subversion, secession, sedition, etc. These were actually laws on national security. And we all know that in 2003, the bill introduced by the Hong Kong government to implement Article 23 was shelved and subsequently withdrawn because of the big protest of an estimated 500,000 people marching in the streets on the 1st of July 2003. And that was, of course, the biggest protest, the biggest demonstration in the history of the Hong Kong SAR until then. And then we know that in 2014, we have this Occupy Central movement in which also tens of thousands of people participated, or even hundreds of thousands at one or two occasions. So that was the second biggest social movement in the history of the Hong Kong SAR. And then last year, that was the third biggest social movement. And this third movement, unlike the first two, was characterized by quite a lot of violence. We all know that the violent protesters joined forces with the peaceful protesters, and the peaceful protesters did not mind being associated or being in an alliance with the violent protesters. They believed that different means of protest could help collectively to achieve the same objective, such as putting forward these 5 big demands, including not only the withdrawal of the bill, but also amnesty or non-prosecution of the protesters, and investigating police, alleged police brutalities, and also realizing genuine universal suffrage. Now, this may be how the protesters looked at the matter, but this is not how the Chinese government looked at the matter. The protesters may think, or most of the protesters may think that what they are doing is not trying to overthrow the Hong Kong government or to get to achieve Hong Kong independence from China, or to engage in subversion against the Chinese government. But as far as I understand, the Chinese government's interpretation of what happened last year was that it was a so-called color revolution, like I think there were different colors to describe various revolutions in former Eastern Europe and elsewhere. So the Chinese government interpreted these events as an attempt backed up by the United States in this emerging Cold War to turn Hong Kong into a base of subversion against the People's Republic of China. So that is basically the theory of the color revolution, using social movement, using civil society forces to topple an existing government. So that was why I think the Chinese government decided to take action. And at the latest NPC meeting, it was revealed that, in fact, the Chinese authorities already decided to take firm action to deal with the threat to national security in Hong Kong. In October last year, at the end of October, there was I think, 4th plenary meeting of the Central Committee of the Chinese Communist Party, which deals with modes of governance and so on. And national security was also mentioned in the context of Hong Kong. So it was revealed that it was then, at that time, that the Chinese authorities decided to deal with the threat to national security in Hong Kong. So, so at the NPC meeting which just took place, it was explained by Chen, one of the deputy chairman of the NPC Standing Committee, that the Chinese authorities considered various options of dealing with this national security threat in Hong Kong. And he actually mentioned several options, including, for example, requiring Hong Kong to enact an Article 23 law, or interpreting the basic law and so on. And it was ultimately decided to choose the present option of so-called two-stage approach. First, the NPC would make a decision on issues of national security in Hong Kong, and secondly, the NPC Standing Committee would be authorized, as authorized by this decision. It will enact a national security law for Hong Kong, which will then be promulgated and put into force in Hong Kong under Annex 3 and Article 18 of the Basic Law. So it was explained that one main factor for the NPC to take this route is that the Hong Kong SL government has not been able to perform its constitutional obligation under Article 23 to enact laws on national security matters since 1997. And on the same day as this NPC decision or the draft was publicized, the Hong Kong Chief Executive, Mrs. Carrie Lam, issued a statement saying that the SEL government is indeed unable or doesn't have the capacity in the present circumstances to legislate on Article 23. So since the Hong Kong government is not able to do it, it is not able to perform its constitutional obligation under Article 23. So, and given that China could consider there is a real threat to national security in Hong Kong, therefore it was decided to take this step of the NPC Standing Committee legislating on national security in Hong Kong. So I would now go on to see, sorry, how many minutes? I've taken about 10 minutes already. So let us look at what is in front of us now. So far, we don't know what the national security law will say. So people who observe Hong Kong events would notice that the stock market dropped very significantly on the day when this matter was publicized. But now, during the last few weeks, it just completely recovered to its pre-NPC decision level. So I think now people in Hong Kong are just watching to see what the national security law will say. There are quite a lot of discussion in the media, in the community on issues that may have to be tackled during the drafting of the national security law. All that we know at the moment is that the national security law will deal with 4 subjects, namely subversion against the regime, secession, and terrorism or anti-terrorism, and so-called foreign interference into Hong Kong affairs. So all that we know is that it would deal with these 4 subjects. We do not know what the provisions are going to be. We do not know what are the issues which are currently in the mind of those who are in charge of drafting this, this legislation. the chief executive and 2 other senior officials were invited to visit Beijing last week to express their views on the matter. But we don't know what was actually discussed. So I suppose there will be consultation between the Hong Kong and Chinese governments on the drafting of this bill. We also know that the top organ in charge of Hong Kong matters is now this leading group on Hong Kong and Macau work, led by the Vice Premier Han Zheng, and the 2 vice chairmen of this group are the Minister for Public Security in China, Mr. Zhao, and also the new director of the Hong Kong and Macau Affairs Office, Mr. Sha. So these are the top people in charge of Hong Kong affairs, including this this bill, I believe. So issues to be tackled are in the bill. I think there are 2 main sets of issues. One concerns the procedure and enforcement. And as you know, the title of this NPC decision includes the term enforcement mechanism. So it's not just about setting up a legal system on national security, but also about its enforcement. So the first set of issues concerns issues of procedure and enforcement, and second set of issues concerns the substantive law, namely how will subversion or secession be defined, if there are criminal offenses, how broad and or narrow they will be. Anti-terrorism law, how would the existing anti-terrorism law be strengthened in Hong Kong? Because at the moment we only have a relatively primitive national anti-terrorism law, certainly much less well developed than that in Canada or in other major common law jurisdictions. And then fourthly, foreign interference into Hong Kong affairs. So how will this be regulated? Will it be regulated by some criminal provisions, or will there be mechanisms of regulation like those now applicable to foreign NGOs in mainland China? Now, let's turn to the procedural enforcement issues, which have been much discussed these days. Firstly, according to the NPC decision, it will be possible for the national security or public security personnel in mainland China to serve in office in Hong Kong. So people are worried about what powers will they have? Will they have law enforcement powers, such as powers of arrest or power of search and seizure, and so on. Then another issue is to what extent the existing judicial system and its procedures will be used to try national security cases in Hong Kong. Will there be some kind of special procedure applicable to such cases or special court? There's some discussion about whether foreign judges, that is judges with foreign nationality, may participate as judges in the trial of such cases. As we know, in Macau a few years ago, the law was amended to prohibit foreign judges from trying such cases in Macau, even though there's never been any prosecution under the national security law or Article 23 law in Macau. And then the procedure of trial, there's been some discussion about whether jury trial will be appropriate for national security cases. So these are examples of procedural issues which will have to be tackled in the course of the drafting of the law. Then there's also the complicated legal or constitutional question of what is the court's power to review to review matters of national security. For example, will the Hong Kong Court has the power to review the constitutionality of the national security law, to consider whether it is compatible with human rights law as currently enforced or understood in Hong Kong, and also what is with the interface between Hong Kong's common law system and this new national security law. In particular, the NPC Standing Committee under the Chinese Constitution will have the power to interpret the national security law, just as it has power to interpret other laws made by the Chinese government. So these are the issues which we currently need to consider, or those who draft this national security law will need to consider. And people in Hong Kong will have the opportunity to express their opinions on these issues in the foreseeable future. So I exceeded my time. So
thank you very much.
That's what I want to say at this moment.
Thank you very much, Professor Chen. Thank you for laying out some of the issues. Some of them, of course, are very much on top of the mind of our audience. They have already asked some questions. So for those who would like to ask questions, we are collecting them in the Q&A, for the Q&A session. If you want to, you can look at the bottom of the screen. There's a Q&A button where you can type in your question. Okay, let's move on to Mr. Wilson Leung. Go ahead.
Thank you, everyone. Thank you for the invitation. I'm probably going to give a bit of a different perspective from that of Professor Chen. And that's the great thing about such a roundtable, is that we can have different voices with different views. So my own background is that I'm a commercial barrister in Hong Kong, but also an activist in the pro-democracy movement. Not one of the big names, but I would describe myself as someone at the coalface of the democracy movement in Hong Kong. And probably of the speakers here, if anyone is going to get in trouble under the security law, it's probably going to be me. So I'll give a bit of that perspective. So I'll give it in two parts. One is about the concerns that civil society and democracy activists have in Hong Kong. And the second perspective is the one of international businesses operating in Hong Kong and what worries they might have. Now, starting from the civil society part, in fact, we've already seen, even before the details of the draft are known, a chilling effect within Hong Kong civil society. So I know of groups who are now worried about who they can talk to, refusing invitations to talk to panels such as this, and even being very careful in whether they express opposition to the law itself. And that's even before the law is enacted and before even the details are known. And that's because despite the Hong Kong officials' best attempts to reassure everyone that everything will be fine, there are many reasons to be worried. It's sort of like a tidal wave coming. Even though the tidal wave hasn't arrived, you can see it coming and you can have a good prediction of what the impact will be when it arrives at your shore. So I think one indication we can see of whether the law will be used harshly or not, and whether it will be used to suppress peaceful dissent or not, is how similar concepts are used in mainland China, and the effect of that is to suppress dissent and activists. So there's many examples of these similar concepts being used in mainland China. For example, we all know Liu Xiaobo, the Nobel Prize laureate. He was the one who drafted a document called Charter 08, which is actually a relatively mild document. When you read it from Western eyes, it seems very innocuous and in fact a bit too mild. But he was imprisoned for this crime of subversion for 11 years. And tragically, he died after 7 years. Another example is a recent case involving a pastor called Hung-yee. He is the leader of one of these churches in China. And he posted up a social media post criticizing the Communist Party for repressing Christians. He was given 9 years for subversion. Another example is human rights lawyer Wang Chenzhang. He acts for a variety of causes, including Falun Gong. He was given 4.5 years for subversion. And for 3 of those years, he couldn't even see a lawyer or his family. And perhaps an example that might resonate with Canadian audiences here is the case of the two Michaels, Michael Kovrig and Michael Spavor. They've been detained in China without trial so far for 1.5 years, much of it without access to lawyers or even consular assistance. And again, they were detained on charges relating to national security. The specific charge there was passing on state secrets to foreign forces. So one can, and of course, I should also mention the case of the Uyghurs, who are up to 1 million Uyghurs in internment camps in Xinjiang province. And of course, the justification given by the Chinese government for that is terrorism. And of course, that's one of the concepts now being introduced with this new law. So, that doesn't give very much assurance to people in Hong Kong that don't worry, it's only violent, radical, separatists, terrorists who are going to be targeted. And in fact, in the Hong Kong situation, there's already numerous indications that Beijing is intending to use it to crack down on speech, mere speech, and peaceful dissent against the Chinese government. So one example is that Jimmy Lai, the proprietor of the Apple Daily newspaper, which takes a pro-democracy stance, he's been targeted repeatedly in Chinese state media, who have said that his current social media postings may be used as evidence against him in a subversion charge. And even though the subversion, of course, law hasn't been enacted yet, we've seen remarks by Hong Kong's Beijing-backed former chief executives, C.Y. Leung and Tung Chee-hwa, hinting that the Tiananmen Vigil might be banned in the future. Now, of course, this is one of the trademark events in Hong Kong's protest calendar, huge candlelight event, entirely peaceful, but the hints are that that might be banned in the future. A pro-Beijing politician, Maria Tam, even said on radio that if someone shouts down with one-party dictatorship at one of these events, then the safe thing to do would be to run away so that you don't get caught with the law. And another pro-Beijing prominent politician, Tam Yu-chung, he's been saying that the pro-democracy camp leaders might be banned from elections for the mere fact that they're opposing the national security law right now. So all the indications there are that this is not something which is targeting small band of violent separatist terrorist radicals. In fact, it will be used to suppress free speech, which the Beijing government doesn't like. And also a word about this, this foreign interference concept. Now, this appears to be a bogeyman that Beijing often uses when things go wrong, especially in Hong Kong. So the 2014 umbrella movement protests, the chief executive of Hong Kong, C.Y. Leung, said at the time that there were foreign forces behind it. And he promised in October 2014 to give evidence of such interference when the time comes. 6 years on, we're still waiting for that evidence. Last year's protest, 2019, the Hong Kong officials, from Carrie Lam down to the police chief, down to the security chief, have been saying that there are foreign forces behind these protests. But when pressed to give evidence of that, the best evidence they could give is that, these protesters seem to be very well organized. They know how to use Apple AirDrop in order to spread their flyers. They know how to use the Telegram app to communicate with each other. So there must be some foreign forces because they're so well organized. So is the flimsiest of evidence, but unfortunately this signifies that what's going to happen when these laws are enacted is that there'll be a witch hunt for these foreign interferences, for foreign forces, and try to root out any local democratic activists who try to link up with international bodies, such as international NGOs, such as international media. Another worrying sign is that the justification repeatedly being used by Hong Kong and Chinese officials is that, the protests are very violent, and so we need to enact these new laws in order to fight against this virus, as they've been calling it. Now, I think it's very debatable whether it's right to characterize these as violent protests. Certainly, the vast majority of the protesters acted in a peaceful and lawful manner. And also one can see that the violence of the protesters as such actually rose very slowly and in commensurate proportion with the violence being exerted by the Hong Kong police. But I think that that's a debate for another time. I think the point I wish to make is that violent acts are already severely criminalized in Hong Kong. There's a vast variety of legal measures to tackle them, and some of which have been widely criticized for being too harsh. So there's, for example, the draconian colonial era offense of rioting, which carries prison sentence of up to 10 years. There's various public order offenses. There's various offenses against the person, such as assault. There's arson offenses, and there's also a anti-terrorist ordinance, which again has been actually commented on by UN special rapporteurs for being perhaps going too far. But the point is that with all these existing laws to tackle violent acts, the question must be asked is, what's the point of then enacting this new suite of national security legislation? And I think a reasonable inference is that what the aim of the Chinese government is to restrict the space for free speech and the space for peaceful dissent against the government. And of course, all these concerns are exacerbated by the fact that in the NPC decision, it envisages that mainland security agents may be stationed within Hong Kong in order to enforce these laws. And of course, the record of the mainland security agents, the human rights records, is not especially encouraging. I'll now go on to the impact on the international business community. Of course, one can only see so much from the stock market because it goes up and down for various reasons. But I think what's telling is the headlines that have been appearing in Hong Kong recently, giving indications as to what they're thinking. So FT headline 2 days ago, Hong Kong hedge funds explore exit as national security law looms. Reuters headline 3 days ago, Hong Kong residents rush for offshore bank accounts on national law worries. Last week, there was a survey by the American Chamber of Commerce. 53% of their member companies were very concerned about the law, and 30% were moderately concerned about the law. So more than 80% were worried. Last week, again, investment bank Nomura reviewing scale of operations in Hong Kong after concerns about the security law. So all these indications, and I suggest that there's 3 reasons why they are and should be concerned. Is because when international businesses operate in Hong Kong, what they really want are 3 things. 1, safety. 2, predictability. And 3, an even playing field. And it's those things that make Hong Kong an attractive destination as compared to, say, mainland China. First, going to safety. Now, there's a real risk that this will be diminished once the law comes into effect. And there's 2 aspects of that. 1 is physical safety, and 2 is safety of assets. Now, physical safety is safety of these international companies' employees in Hong Kong. I mentioned the example of the 2 Michaels, 2 Canadians who are being held in the mainland. But there's also another example one can use, is that in 2015, a UK hedge fund called Man Group, a very large hedge fund, they were blamed for causing the market crash in China in 2015. And it was said that they had they were foreign forces who were sabotaged the Chinese market. And several of their employees, including its head of China in Beijing, were actually detained for several weeks by mainland security forces. So when you have these examples, it's not very encouraging sign for international businesses who wish to base their operations and their staff here.
Wasn't 2 more,
sorry.
2 more minutes?
Oh, yes. And especially with the worsening relations between the Western world and China, Western companies will really have to think twice whether they want to send their staff here. And the second and third is predictability and even playing field. Predictability, the problem is that national security is defined very widely by the PRC. Under its own 2015 national security law, it includes threats to sovereignty, territorial integrity, but also welfare of the people, sustainable economic development, and other major interests of the state. So once these companies are in Hong Kong, it's going to be very difficult for them to predict what will cross the red line. And lastly, even playing field with these concepts such as national security, incoming concept of state secrets, they will really have to think twice whether they will have an even playing field vis-a-vis Chinese state-owned enterprises who will be their counterparts operating in Hong Kong. So in summary, in my view, there's many reasons to be worried, both for civil society and also for the international business community. Thank you very much.
Thank you, Mr. Leung. I'm sure we'll come back to some of these issues raised in the Q&A session. Thank you. Professor Cheng. You're muted, so yes.
Okay. Since no one's using the PowerPoint, I'm going to just talk. So there have been many discussions of the concerns of the national security law for Hong Kong. As any other national security law, the major challenges of the legislation is how to strike the balance of 2 sets of concerns, freedom of expression and national security interests. But why the enactment for Hong Kong is so controversial? My perspective is probably more from a comparative perspective. My observation is that this law is the product of the battle of identity politics. It is part of the battle, which incentivized by the intention to win by the Central People's Government but it also aims to change the paranoid style politics. Thus, it may provide an opportunity for compromise in order to end extreme actions and hate speech. So the origin of identity politics in Hong Kong is actually relatively new. After 1997, the post-colonial government has tried various ways to make people in Hong Kong identify more with China, but
let's see. We have a freezing session. Let's see.
Looks like most Hong Kong people just take it like indifferent of those efforts. In 2003,
Jie, we lost you for about 30 seconds. So could you roll back 30 seconds?
Yeah.
Your audio did not come through for about 30 seconds.
Oh,
so we missed a little bit of what you had to say. So if you can just go back.
I think you are just talking about identities, and then we did not hear what you said.
Okay, I'm trying to explain that the identity politics in Hong Kong is relatively new. And in the beginning of the return of Hong Kong after 1997, even though the post-colonial government has tried various ways to make people in Hong Kong identify more with China, most Hong Kong people seems to be rather indifferent to these actions. But in 2003, the withdrawal of the national security bill altered many and alerted many that reunification with Hong Kong is incomplete unless there is a return of heart, right? This is what the Chinese government term it. And then in 2012, the national education project propagated by the Hong Kong government was halted by the social movement led by Joshua Wong and his cohort, which marked the rise of new generation political forces. In 2014, again, with the succeed of occupying the central, the umbrella movement, and then the withdrawal of the electoral reform, the younger generation politicians gained even wider alliances and reinforced the narrative of the new communal identity for Hong Kong people as Hong Kong people, but not necessarily Chinese, part of China or as Chinese. And then in 2019, the social movement against the extradition bill again highlighted the identity politics. So basically what the identity politics in Hong Kong has created bipolarization and the sort of paranoid style politics, which can be witnessed in other communities as well. First of all, we can see that in the Legislative Council, there has been a sort of tit-for-tat escalation in which parties resort to employ the filibusters. So filibusters, even in the United States, tend to be kind of rare before 1970s and 1980s. But in Hong Kong, even though it was not in the basic law, many political groups, the representatives from the political groups, both from the pro-democracy and the pro-establishment employ many of the filibusters, even in recently. And then secondly, unlike previous pro-democracy groups, the new generation tend to utilize social movements and massive protests against the establishment instead of legal proceedings. And then finally, we can see the war of words escalated in almost all aspects of social and political lives. I created a kind of a form of war of wars, and you can, I can, quickly go through it. For example, the pro-nationalism would like to term the personal identity as patriots, while pro-localism tend to term themselves as pro-self-determination. And then in terms of national-regional relationship, pro-nationalism tend to term it as, we should work for national integration, while pro-localism tend to emphasize autonomy. And again, in terms of the view of British rule, pro-nationalism tend to term it as colonial rule, while the pro-localism tend to term it as, the legacy for liberty and democracy. And then again, pro-nationalism tend to view mutual, the other side as, the image of the other side is kind of a cockroach for the pro-localism, while the pro-localism call pro-nationalism as 五毛, the 50 cents, or locusts, right? So there has been all kinds of these escalations of mutual allegation and attacks. Worst of all, we have seen escalation of violence. Like for the nationalists, there has been, market blockade for pro-localism, and also both for business and for individuals. For example, some of the actors or actresses were blocked in Chinese entertainment, and also some of the business were also, the owners of the stores were snatched, or they kind of sanctioned for being sympathetic with the pro-localism. Well, at the same time, we have seen vandalism of pro-Beijing or pro or those who branded themselves as patriots. The stores were vandalized, or persons, either representatives or other individuals, may be physically attacked by some extreme pro-localists. Worst of all, you have seen this new trend of doubts of the independence of the judiciary. Pro-nationalism may criticize the judiciary for being lenient towards the rioters, while the pro-localism criticized the judiciary for criminalizing protesters and invalidating oath-taking the oath-taking cases. So for the national security legislation, even though the official explanation is to prevent and punish secession, subversion, terrorism, and foreign political organization manipulation, but the real goals is to are two. One of them is to restore of trust of the establishment, both from the central government side and from the Hong Kong establishment. This establishment include both the government and non-government establishment, including the judiciary. The second, potential target is to set a limit for the reconfiguration of the communal identity, because the mutual exclusion has escalated to the extent that there is a identity crisis, and this crisis constitute some kind of a national security crisis. So my view is that this legislation at some point created an opportunity for compromise, because in order to have this law enforced, sincerely enforced, right? Because otherwise it's just a law. It might be interpreted to be more pro nationalism, or to be more pro-liberalism, or more pro-localism. China needs to, even though China may have an upper hand, it may make the law whatever it wants, but the manipulation will only waste the moment for compromise and to restore order. And restoring order, including to restore the credibility of the establishment, is a common consensus among the establishment. Is probably the hope of many localists as well. And in this sense, I'd like to say that you know, if we take a comparative perspective, Canada's experience may contribute to this process, given the fact that Canada has the knowledge of dealing with some of the very complicated cultural and ethnic crises in the history. For example, Canada has bidualism and asymmetric federalism to accommodate the legal system of Quebec. Canada has the Truth and Reconciliation programs to indemnify the Aboriginal peoples, and Canada also has a relatively friendly immigration policy, which may potentially provide an opportunity for Hong Kongers who choose to vote with their feet. To be honest, I don't think the law will really harshly, draconically enforce in Hong Kong, because that means that the Hong Kong people may immigrate to other countries, or that the central government will completely lose its credibility. And it does need the Hong Kong establishment, including the judiciary, to keep the order and prosperity of Hong Kong. So to summarize, I tend to believe that despite the legitimate concerns of national security and freedom of expression, the law is the result of the battle of the identity politics. But in order to end the paranoid symptoms created by the battle, it provides an opportunity to compromise in order to resume a more rational discourse in Hong Kong. Then in the end, I'd like to use a quote from Stephen Levitsky in his How Democracies Die. He says, "But at the end of the day, we recognize publicly, and we tell this to our followers, that the other side is equally patriotic, and that it can govern legitimately." So which are the mutual allegations of the two sides in Hong Kong, and which may bring some inspirations for a meaningful compromise in order to resume or to restore order in Hong Kong in the future. Yeah, thank you.
Thank you, Professor Cheng, for the reading of the situation and for your intervention. Thank you. Professor Potter.
Thank you very much, and thanks very much to Professor Shin and also to the Hong Kong Studies Initiative at UBC and others involved for the opportunity to join this important discussion. I'd also like to thank the other panelists for educating me on the relevant issues. That's the benefit of going last, is that I get to hear what everybody else has to say. So that's great. Now, I think it's important to recognize, as many have, that the passage of the NPC decision on enacting a national security law for Hong Kong stands against a lengthy historical context. And other panelists have raised these, but I'm just going to touch on a couple of items that I didn't hear get raised or didn't get as much or should be reiterated. I think the debate over patriotic education policy in 2012 was mentioned, and that's an important element. Of course, the umbrella movement and the subsequent sentencing of umbrella movement leaders is part of that historical context. Another important feature is the rebound of the Hong Kong Democratic Party and the major victory for pro-Democrats in the district council elections in 2019. I think it's also important to note the intensity of the extradition bill protests of last year, and then also the arrests of numerous 15 or so democracy activists earlier this year, including a number of other luminaries in the Hong Kong democracy movement. And so those also serve as context. And I think it's very interesting that there seems to me, for me at least, to be a parallel between the attitudes of many of the people who are resisting the current initiative and who have been active in pro-democracy events in Hong Kong and the anti-racism demonstrations in the United States, which is to say, these are expressions of political will which have reflected pent-up frustration. So if we look at the timeline on political expression in Hong Kong, if we just go back to the Article 23 Securities Ordinance issues, that was more than 15 years ago. And when we think about the anti-racism discussions in the United States, those have been going on for a long time. So a lot of the attitudes and behavior, I think, are reflect a very similar dynamic of pent-up frustration. And frankly, I think the responses in both China and the United States have been similar, which is more interested in suppressing expression than in cooperating with it. I think it's also important to note, as a matter of methodology, that the responses of the PRC government and the Hong Kong Special Administrative Region government, these are not uniform and monolithic phenomenon. It's important to unpack, as Professor Cheng has started to do, a lot of the internal political culture and policies that undermine legal initiatives. And whether it's China or Hong Kong or elsewhere, we need to think about legal initiatives not as the product of monolithic government, but rather as the product of a long and dynamic process of negotiation and disagreement and so on, much of which in the PRC context is hidden from view, but it nonetheless has been identified by many scholars. I would also just encourage us to avoid the Manichaean dualism, which tends to, forgive my other hat here, but the Manichaean dualism that tends to separate good and evil and pro and anti forces and so on. When we think about the views of those supporting the NPC decision, those opposing the NPC decision, those supporting and opposing various elements of PRC initiative in Hong Kong, it's very important, I think, to consider a spectrum of variation rather than clustering responses into a pro and anti category, because that is a Manichaean dualism, and I think it's actually not helpful in understanding something as complex as what we are seeing. So let me turn just to the decision itself and highlight a number of points that were made, and Professor Albert Chen touched on these, but I think one of the key issues is language in the decision is in Article 1, preserving the constitutional order of the Hong Kong SAR as determined by the Constitution, by the PRC Constitution. So that makes it unavoidable that we would get into constitutional discourse in China in terms of the interpretation of what national security means, what the rule of law means, what the Hong Kong legal system means. And that's important. And of course, as Professor Chen noted, national security is a key element, but there are other elements in the decision that touch on separatism, subversion of state power, terrorism, and activities by foreign forces. So there's some very specific guidance in this decision that can help us sort of forecast where things are going. I would also call people's attention to the very recent analysis by Johannes Chen, who offered a compelling analysis on the relationship between the NPC decision and the Hong Kong Basic Law. I leave that to my colleagues in Hong Kong to unpack in more detail, but clearly there is a very detailed set of legal arguments to be made as to the consistency of the NPC decision with Hong Kong law. While most attention has been focused on the national security dimensions of the decision, obviously, the decision potentially goes much farther than that through its provisions on preserving the constitutional order and on establishing and completing the Hong Kong Special Administration region's legal system and enforcement mechanisms for preserving national security. So what this raises for me is fundamental questions about how the PRC deals with the rule of law. And this is an old issue. Many colleagues, including ones who are at our panel, as well as folks like Fu Hualing and Jerry Cohen and Mike Davis and others, have addressed this for many years, and I've been privileged to be part of some of that discussion. But it seems to be the key question. Because if we are looking at the constitutional order, if we are looking about the Hong Kong legal system, and there are methods to improve that or strengthen that or change that, the underpinning principles of the rule of law are just unavoidable. So I think it's important to note that although there's a lot of debate about the rule of law under the Chinese socialist rule of law context, I think it's fair to say that it's not what Albert V. Dicey had in mind when Dicey first started to coin the idea of the rule of law and the rule of law binding the state as just another actor in addition to binding society. And I think that it's important to also recognize that this was an important counterpoint to Dicey's other important theory on parliamentary supremacy. And what we see in China all too often is we see the principle of parliamentary supremacy being carried out. The NPC enacts things, and its democratic process is there for folks to debate and disagree with and what have you. But once that's done, that is seen as all there is that's needed to justify particular laws. That, in my estimation, is not the rule of law. That is the rule by law. It is the rule of laws. And when we look at Dicey's approach, and we see it applied in civil jurisdictions, the German Rechtsstaat, for example, the French system of état de droit, we see many international efforts that are about rule of law principles that constrain the state. And I think the evidence in the PRC is very strong that while PRC law restrains officials, and the key is to restrain implementing lower level officials from corruption and malfeasance and so on and so forth, that is not the rule of law. That is rule by law. And I know that there are colleagues and friends who will disagree with me and talk about the thin rule of law and all the rest of it. But at the end of the day, the core concept of the rule of law is that it applies to the state as well as society. And we don't really see that, at least very often, in China. So when we look at the Chinese socialist rule of law, it's really a set of rules by which governance is exercised. And of course, there is important value to restraining the arbitrary and corrupt behavior of subordinate officials. But there still remains no meaningful restraint on the decision-making and activities and policies of the party state itself. And that allows the party state to basically use law to carry out its will. And that is what we see with the NPC decision. And I think it's important to recognize that, and that affects the way we respond to it. So let me just touch on a few examples of that. Of course, and I think it was mentioned already, the fourth plenum of the 18th Central Communist Party Central Committee in 2014 talked about the position of the leadership of the Chinese Communist Party as the foundation for all legal activities. So when the leadership of the party is the foundation for all legal activities, it's very hard to make the argument that law constrains the party. We saw this repeated in the fourth plenum of the 19th CPC Congress in 2019, just last year, which reiterates the point of party leadership over the legal system. And then there are another of other examples, such as the party's new regulations on political legal work, which extend party dominance to all activities of the judiciary, all SIFA activities. So there is clearly an orthodoxy. I'm working on a book on this, so forgive me, but an orthodoxy of party dominance, which affects the way that the legal system operates in China. And that ought to be of some concern to people in Hong Kong, especially when we see the NPC deciding, according to Chinese socialist legal system principles, to push forward a legislative position in Hong Kong. Now, we see this actually, the dominance of the party in many instances in the PRC, but certainly one is the Constitution. And so when we see a reference in the NPC decision of upholding the constitutional order according to the PRC Constitution, that means we have to look at the four cardinal principles, which involve party leadership. We have to look at the conditionality principle, which is expressed in Article 51 of the Constitution, which says citizens in exercising their freedoms may not infringe on the interests of the state. We see it in lawmaking, the legislation law, both Article 3 on legislation and Article 56 on administrative regulations talks about the importance of party leadership. We see it in the behavior of lawyers. The lawyers' law, the All China Lawyers Association Code of Conduct, all requires lawyers to be subordinate to party leadership. And then we see, with respect to judges and courts, we see the Supreme People's Court interpretation in 2010 about adjudication committees and the importance of the so-called Sangha Zhishang, which is to require reliance on party leadership. We see, as I mentioned before, the CPC regulations on political legal work from January 2019, which says all political legal organs, that's courts, procuracies, public security, state security, judicial administrative organs, are required to uphold the absolute leadership of the party. And then finally, more recently, just in April of this year, we have a Supreme People's Court interpretation of the fourth plenum of the 19th CPC Congress that requires party leadership over all judicial sifa activities. So when we think about that, it helps explain a lot of the regime's behavior when it comes to human rights and expression. We look at document number 9 of a number of years ago. We look at the treatment of rights defenders, lawyers. We look at the treatment of Charter 08 and Liu Xiaobo. We look at the treatment of religion. We look at the treatment of Xinjiang. We see the conferring of presidency for life on Chairman Xi Jinping. And we see China's, we see all of those as carrying out this orthodoxy of party supremacy. And I would suggest that this also spills into China's overseas behavior with regard to treaty performance. So whether it's South China Sea matters and the Philippine arbitration, whether it's the Belt and Road, we see continuation of the theme and the orthodoxy of party dominance over legal activity. So when we think about the NPC decision, it's important, and it's not hidden. It's not subtle. It's right in the language of the decision that PRC approaches to the socialist rule of law as conferred by constitutional order language are very much in evidence in the NPC decision and the potential legislation that may spring from it. So let me just, in the few minutes I have left, I'll just touch on a few of the applications in Hong Kong. When we think of the application of the NPC terms, of the Constitution matter I've mentioned, the Hong Kong legal system matter I've mentioned, but when we look at national security, it's really worth remembering, as Wilson Leung pointed out, that Article 2 of the National Security Law defines national security as the relative absence of international or domestic threats to the state's power to govern, sovereignty, unity, territorial integrity, welfare of the people, sustainable economic and social development, and other major national interests, and the ability of the state to ensure a continued state of security. National security involves an attitude. It involves the relative absence of threat. That means that those who are claiming that they are not a threat to national security must prove a negative, which of course is quite difficult. So I think the way that national security is defined in Chinese legislation reflects potential difficulties in its application elsewhere because of that proving a negative problem. When we look at separatism, it's useful to look at China's anti-secession law with regard to Taiwan, which talks about preserving China's sovereign and territorial integrity and safeguarding the fundamental interests of the Chinese nation. When we look at, again, the national security law, we talk about separatism in light of national sovereignty, unity, and territorial integrity. When we look at Xi Jinping's speech in 2016, just one of many, that says we will never allow any person, group, or political party to split China from part of its territory. When we see the proposed Article 23 Securities Ordinance that didn't go through, but nonetheless had language that may well influence interpretations going forward. We see in the proposed amendment to the Hong Kong Crimes Ordinance, Section 2B, a person commits secession if he withdraws or uses force or seriously criminal means. I'm not sure what that even means. That seriously endangers territorial integrity. So the possibility of expansive interpretation of the separatist language is very key, and we would look at it on top of the party dominance orthodoxy. It does cause some concerns. When we look at subversion of state power, the criminal law of the PRC in Article 13 talks about an act that endangers the sovereignty, territorial integrity, and security of the state. And again, how is that interpreted? What does it mean? And so on. We see in Article 105 of the criminal law, whoever incites others by spreading rumors or slanders or any other means to subvert state power or to overthrow the socialist system. So it's the very vagueness of the language coupled by the dominance of party policy and interpreting that language that is something that should be paid attention to. When we look at, again, in the proposed Article 23 that didn't come through, but nonetheless, the language is still in circulation, we look at subversion as about disestablishing the basic system of the PRC. That means 4 basic principles. That means socialist road, people's democratic dictatorship, those sorts of things. Overthrows the intimidates the central people's government by force or serious criminal means. Again, this is language that is going to be required to be interpreted by judges, by officials. And when the interpretation process is dominated by the party and its objectives, that gives cause for potential concern as to how this language may be imposed or interpreted in China, in Hong Kong rather. We see similar issues on the terrorism issue, whether we look at the UN standard on terrorism, which has been adapted in Hong Kong, or we look at China's 2019 anti-terrorism law. It really looks at actions that create social panic, endanger public safety. Endanger public safety. You know, when the police brutality demonstrations are being carried out in the United States and the opposition to use of police force, many police officers interviewed are saying they are protecting public safety. So that illustrates how this is a term that can be interpreted in many different ways. And so we have to look at what are the underlying principles, and then we get back to the party orthodoxy of law. So it's interesting that the foreign and overseas interference, although it is customary among many international scholars and officials to sort of downplay that, I think it is important that China preserves its sovereignty with great vigilance and is very opposed to foreign behavior and perhaps assumes a greater level of coordination of foreign behavior, so that in the context of the 219-220 extradition protests, China protested the, quote, black hand, end quote, of foreign involvement, which basically meant newspaper journalists and NGOs trying to understand the matter better. So it is important to just try to unpack that language. Now, Wilson Leung treated very well the question of the impact on Hong Kong as a trade and financial hub. And I would just say that this decision has the potential to undermine confidence in the rule of law. And Wilson Leung talked about that, but that confidence in undermining in the rule of law is just essential. When we look at the first year contract textbook that used to be published by West Publishing House, and in that textbook, it defined contracts as agreements between people who don't trust each other. In other words, it defined contracts as agreements that would be enforced by a legal system regardless of its relationship to the parties. And that confidence in the rule of law is essential to contract behavior, property behavior, and so on. So in addition to those issues which Wilson Leung talked about so well, I just wanted to also say that the NPC process is potentially—
1 more minute, Pitman.
Yep, thank you. Looking at the potential for imposing PRC trade policy on Hong Kong interests. And PRC trade policy is very much tied to the political economy in China. Remember that building a market economy was a criteria for China's accession to the WTO. And also note that not long ago, the Chinese government indicated that a market economy is an economy under the leadership of the Chinese Communist Party. So there are those other issues that are at play whenever China starts to impose its standards on Hong Kong, and the NPC decision is potentially an indicator of that. It's obviously too early to tell, although there have been some indicators already. Last point I'd like to make is about the impact for Canada. So the importance of Hong Kong to Canada is well documented. 300,000 Canadian citizens in Hong Kong, 500,000 people of Hong Kong descent in Canada. Hong Kong is Canada's 10th largest export market. There are very deep education and sociocultural links. In fact, I think it's fair to say that the Hong Kong Studies Initiative at UBC is a reflection of those deep, deep ties. It's also important to recognize the appointment of Madam Chief Justice Beverly McLaughlin as a non-resident foreign justice on the Hong Kong Court of Final Appeal. That indicates the close relationship between Hong Kong and Canada with regard to law, the economy, society, and so on. So clearly, this is going to have an impact. And the key for me is the role of the socialist rule of law on treaty performance. If we look at bilateral trade treaties, the investment agreement, the FIPA agreement, even the possible discussion of a free trade agreement. All of those are going to be affected by confidence in the rule of law. And if we don't see that coming from China, it's going to be difficult to have confidence in those agreements. When we look at the Meng Wanzhou matter that has been captivating so much attention, China's retaliation on canola, on beef, and so on, there wasn't even an effort to justify it under the WTO. They just did it. And when they said, how can we get rid of these? You have to correct your past mistakes, was the answer. Clearly, it was the politicization of trade sanctions, which goes directly against China's commitments to the WTO. And lastly, on the political relations, it was already mentioned the two Michaels, but I can't avoid saying that when the charge that is brought is a charge of state secrets, I would commend to your attention the definition of state secrets in the Chinese state secrets law, and it is so expansive that it tends to be the last thing Chinese prosecutors get to when they can't find anything else. So it does show, again, the politicization of this legal relationship with respect to the two Michaels, but it also affects consular agreement, the potential for an extradition agreement, cooperation agreements between China and China and Canada on fentanyl, money laundering, and other things. So the effect on Canada is very, very important, and it basically boils down to lack of confidence in the rule of law. And it's not the socialist rule of law that exempts the party by definition. It is the rule of law that binds the state just like it binds people. And until that uncertainty, those questions are really dealt with, this kind of decision and others like it are going to meet with the kinds of reactions that we've seen. Okay, thanks very much, and I'm sorry I went over time.
Thank you, Professor Potter. Thank you very much for the panelists for sharing their thought. And I should mention that particularly Professor Albert Chen is very busy, and he has an engagement that he has to go. So he will have to leave a little bit early at 8:45. So we still have a bit of time, but I do want to make sure that we can hear from Professor Chen as much as possible before he leaves us. So I have, of course, already collected quite a few questions from our attendees as well as from others. And so in general, I think there are three sets of questions, right? Three areas that people are interested in. Of course, there are many areas as well, but three that I can sort of group together. So one area has to do with impacts, right? So of course, the details of the law are still being worked out, but many of us are very interested and perhaps concerned about the potential impacts on the civil society, on dissenters, and even on visitors, on business people, et cetera, et cetera. So that's one general area, is a question about impact, potential impact. Another area has to do with trust. And in some way, I think Professor Potter may not use that word, but is pointing in that direction. That is, given the track record of China's version of rule of law, why should we trust China? Right, so that's the general question about trust. And then the third component has to do with procedures. That is, how is it actually going to work? What is the timeline? What is the role of the courts in Hong Kong? Who gets the interpretation, et cetera, et cetera. So on that note, I do want to ask a very particular question. It's a bit of a long one from a community member, a very respected community member, but I think it does point to this, the question about trust. So let me sort of read them, and bear with me, it's a bit long. So the Constitution of the PRC promises all kinds of freedom. In Article 33, the state shall respect and protect human rights. Article 34, all citizens shall have the right to vote and stand for election. So I should mention that this is the Constitution of PRC, right? And then Article 35, all citizens shall enjoy freedom of speech, freedom of the press, et cetera, et cetera. The question goes on. Any observer who is not willfully blind would observe that the Chinese Communist Party has broken every one of those promises to the people of China. Therefore, the key is not what the law says, but who has the ultimate authority to interpret the law. The key is not how well you draft the wording of the law, but how well the enforcer of the law appreciates and adheres to the spirit of the law. We know that the national security law in China has been often used to silence dissent. We also know that pursuant to the Basic Law of Hong Kong, the National People's Congress has the ultimate authority to interpret the laws in Hong Kong. So here's the question. What is there to prevent the Hong Kong government from likewise using the national security law in Hong Kong to silence dissent? And what is there to stop the Chinese government from using its ultimate authority to interpret the national security law of Hong Kong to suit its political whims? So that's the question, a long one, but an important one, I think, from a community member. So the floor is open to the panelists, whoever wants to perhaps use this opportunity to address the issue about trust. Perhaps but Pitman, can I ask Professor Cheng if he would like to address this issue first?
Please.
Professor Chen is muted. Would you like to address this? Let me see if I can.
Okay, yes. I think the issue of trust exists irrespective of whether there is any national security law in Hong Kong. As Professor Potters just mentioned, I mean, even if we put aside the national security law issue, there are questions about what is the socialist rule of law in China, whether it is no more than rule by law. And Professor Potters also talked about the party dominance and so on. So I think we should separate two sets of issues. One are issues concerning the Chinese legal system and the Chinese practice of rule of law or rule by law. That's one thing. And the other is the implications of the proposed national security law in Hong Kong. So I think it is significant to note that China has decided not to simply apply its own national security laws to Hong Kong, because we all know that there are various laws relating to national security in China, including provisions in the criminal code on offenses against national security. So the Chinese authorities' present approach is that they will not apply these mainland laws to Hong Kong under Annex 3 of the Basic Law. Instead, they will draft a new national security law that is suitable for the circumstances of Hong Kong. So I suppose they will not just impose the mainland definitions or concepts of subversion or secession in Hong Kong. Just as in the case of the 2003 bill on national security in Hong Kong. At that time, the Hong Kong government drafted its own bill. It was not drafted by the mainland. And actually, the Hong Kong government sent the bill to England and asked a very famous Queen's Counsel, David Panic, to comment on whether the bill was consistent with the international human rights guarantees in the ICCPR, the International Covenant on Civil and Political Rights. And Mr. Panic actually gave an opinion saying that in his opinion, it was consistent, the bill was consistent with these human rights standards. Now, we don't know what this national security law, which is now being drafted, will say, and whether it will be similar to the 2003 bill or more draconian and so on. So that is an unknown, but we do know that there's been comments from both the chief executive and the secretary for justice in Hong Kong since the announcement of the NPC decision that they believe that the law would be mainly enforced by the Hong Kong authorities. The cases under the law will be tried by the Hong Kong courts. It is said that by the chief executive that the law will not affect judicial independence and the power of adjudication and the power of final adjudication by the Hong Kong judiciary. So it is significant that at least on the face of it, without the law the content of law being known. Or we do know that the Hong Kong government is trying to assure members of the public in Hong Kong that that the law will be applied and enforced within Hong Kong's existing legal and judicial system. So insofar as the existing Hong Kong system does adhere to the rule of law, we hope that rule of law standards will continue to be applied even after the national security law is enacted. So that's all I want to say at this stage. I can stay for a few more minutes after quarter to 12. Sorry?
Sorry. Thank you very much, Professor Chen. I was muted. Thank you very much for staying with us. Professor Potter?
Thank you. Well, I am reminded that on the importance of trust. And I think it's worth noting that in the Analects of Confucius, there is a passage where a disciple of Confucius asks, what is necessary for governance? And the reason this is relevant, of course, is that China in recent years has very consciously and openly adopted an allegiance to Confucianism, in part as a explanatory device, as part of a legitimation device for political and legal activities. So I think it is relevant. And the master's response to this question was, the state must preserve its weapons, first. It must ensure there is enough food, second. And it must ensure there is trust. And if there is no trust, all is lost. The master's words, not mine. So I think the key issue of trust is absolutely essential. And when we look at popular surveys in China, they tend to suggest that there's a great deal of trust in the central government, but less in local governments. And surveys in China have indicated that the more contact individuals have with government officials, the less trust they have. So I don't know what the answer is, but clearly it is a key issue. So when we look at, I mean, hope springs eternal, and I hope for the best. But when we look at the interpretation of Hong Kong law and the interpretation of the NPC decision, yes, I think we can say that PRC law and Hong Kong law are different. We can say they have different origins. We can say there have been many statements by political leaders on both sides of many issues and between Hong Kong and China talking about the difference. But the NPC decision is a clear intrusion of PRC government into lawmaking in Hong Kong. The PRC decision says very specifically that they will draft laws and that they will include those laws as an annex to the basic law. So clearly, whatever difference might have been imagined at one time, might have been hoped for all this time, and is still hoped for going future, is clearly brought into some question by this decision. Now it may be a one-off prompted by alarm over social unrest and so on, and that may be the case. It's an exception rather than the rule, but it is a clear erosion of the separation of Hong Kong law from PRC law, and so that leads us to questions about how law will be interpreted. And so when we look at what are the sources likely to be of the NPC drafting laws on national security for Hong Kong, it is not, in my mind, unreasonable to look at many of the legal precedents that NPC deputies and delegates have at their disposal. And if we look at the makeup of the NPC Legal Affairs Committee and all the rest of it, it is not unreasonable to expect them to look at PRC precedents as well as others. But I think that's something that we will not, of course, know until the final laws are enacted. But I think it's something that should be paid attention to. And when we're looking at legislative history, looking at the normative origins of particular statements like national security, secession, subversion, and so on, are very illuminating in terms of potential outcomes in the drafting process. Thank you.
I wonder whether Mr. Leung and Professor Cheng have any, Jack, go ahead, please. You may want to unmute yourself, yes. Yes.
Okay, thank you for the question. I think the trust or the credibility concern is very important. But I'd like to say that the trust concern is actually, it's mutual distrust.
the localists do not trust the nationalists or the central government, and the central government do have concerns of foreign interference and some other kind of conspiracy theories from both sides. So the real question is why, or how do we demystify the Central People's Government's behaviors? First of all, I don't think, as a common knowledge, China is not a liberal democracy of American style. It's its own kind of, I'd like to say it's a patriarch society. So the incentive for China to make a national security law in order to quell the paranoia may come from three different reasons. First of all, there is already a crisis, and both establishment in Hong Kong and the central government wanted to restore order. And second, in order to restore order, you have two choices. Neither of them is desirable by the Central People's Government. The first one is the conventional one, when the pro-democracy would like to challenge the establishment through cases. Like Professor Johannes Chen said that it's a battle between David and the giant, right? So the metaphor is that you don't incite a massive movement in order to counteract the central government. So, and another option is a social movement, social revolution. Comparatively, the conventional pro-democracy seems to be more trustworthy than the pro-localist movement. And the third concern is that you can never really trust anyone, either in a liberal democracy or even in a patriarch society. But you do need to trust that there is the fact is that the central government does have an upper hand, right? So in the end of the day, you need to give some kind of trust of self-restraint of the Central People's Government. Otherwise, because the central government has the upper hand, it does have the power to suppress, to dictate, to have to be a tyrant. But what's the benefit of being that, right? So, and of course, in the end of the day, as I have used the metaphor of Naja for the younger generation in Hong Kong, there is a unfortunate fate of integration between China and the mainland. So it's very important to have a voice from Hong Kong, especially from the younger generation. But there's also need a moment for compromise and for moving on.
Thank you, Professor Cheng. Wilson, do you have any thoughts about the question?
Yeah, I think the question is a very good one. And in fact, trust is something that needs to be earned, not just through empty words. But I would emphasize that it's something that needs to be earned, especially by government authorities. And the burden on the governments to earn the trust is especially high. And the reason is because the government holds all the levers of power. They have all the physical force, they have all the weapons, and in the Hong Kong legal system, in fact, Beijing has all the legal power because they have the nuclear weapon of the interpretation of the basic law. And of course, the government also has a chain of command. Carrie Lam gives the command to her ministers give the command down to their departments. Whereas activists or the protesters don't have a chain of command. So for example, if you see 20 people holding US flags, it's not as if Martin Lee can get on stage and order those people to take off the flags, because it might give rise to unfortunate perceptions. So I would suggest that actually the burden is much higher on the government to prove that it is worthy of the trust which it asked the people to give it. And I would suggest that so far the Hong Kong and Beijing governments have not been doing a good job of earning that trust. One example is the way it is going about this national security law. There's a mechanism for doing it in Article 23, which is for doing it through Hong Kong's own legislature, which is already controlled by pro-Beijing parties. But at least it enables this sort of open process, the one that Professor Chen referred to, where there was a consultation, there was taking advice from a London Queen's Council, people debated about it, looked at the draft, the Bar Association commented extensively, and so on. But skip forward to 2020, and it's all being done in a black box and simply being imposed on Hong Kong people.
Thank you. I would like to, again, to capitalize on Professor Chen's presence, move on to another question about potential impacts, right? So there's a question by one of the attendees today. What is your speculation on how this law would affect the daily lives of your average citizen or visitor? Now, again, I understand that we don't know all the details of the law, so it is speculation. But it is very much on top of the mind of many people who are concerned about the law. That is, what will be the impact? Can you, the panelists, can you imagine for us what the daily life would look like, would be different after the passing of the law? Maybe we'll start with Mr. Leung.
Thank you. Well, we've already seen, my prediction is that there will be even more severe chilling effect on people's ability to criticize the government in Hong Kong and government in Beijing. Now, we've already seen a steady erosion of that ability in recent years. So for example, last week, there's an article in the New York Times titled, "In Hong Kong, China Threatens Businesses and Workers." And that's before the national security law. And the gist of that is that in Hong Kong, there's now a lot of economic pressure placed on people not to speak out. The cases last year include Cathay Pacific firing dozens of its employees just for posting pro-protest messages on their personal social media account. And of course, recently, we also have the cases where even big multinational companies such as HSBC and Standard Chartered were effectively compelled to sign up and vocally support the national security law. But this sort of trend will accelerate once the law is implemented. When you have these quite draconian concepts, and which we can all see how they're used on the mainland, backed up by heavy sentences, and also the possibility of mainland security agents. There's going to be a severe chilling effect, and even sort of hardened activists will have to think twice and three times before they vocalize criticisms.
Thank you. Professor Chen?
Yes, I think we have to pay attention to what the Chinese leaders are saying as regards this law. So they have said several times recently that the law will only affect an extremely small number of people, 极少数人. So I think what they have in mind is that most people should not be affected. They are not going to pursue the responsibility of the hundreds of thousands of protesters who engaged in demonstrations last year. They are the majority of people. I think there's no doubt that if not a million, at least hundreds of thousands of people did participate in some of the demonstrations last year. So the law is not, as I believe, the law is not targeted at these people. I think we also have to note some sayings of the Chinese leaders. Xi Jinping visited Hong Kong in 2017 to celebrate the 30th anniversary of the to celebrate the 20th anniversary of the handover. And he said that there are certain actions which cross the red line and which will not be tolerated by the Chinese authorities, such as calling for Hong Kong independence or trying to subvert the Chinese government. And recently, it has also been said that the US is trying to use Hong Kong as a bridgehead or a beachhead for subversion of the Communist Party-led regime in mainland China. So I think the main reason, as I understand it, for the enactment of this law, what some people perceive to be relatively drastic action in relation to Hong Kong, is to protect China's national security. That is basically to prevent Hong Kong from being used as a so-called bridgehead or beachhead for trying to change the regime, the political system in mainland China. So this idea of crossing the red line, I think, should be taken seriously. If there were no anti-extradition movement in which so much violent protests occurred, Chinese authorities would not have been led to believe that the red line has been crossed. And if the red line has not been crossed, I don't think they would have introduced this law. So I think it is a kind of vicious circle. Hong Kong people did say certain things which touched the nerves of the Chinese authorities. They tried to challenge the red line, cross the red line, and the Chinese authorities decided to react. So the more Hong Kong people try to challenge or cross the red line, the more actions will be taken by the Chinese authorities to maintain what they perceive to be the national security of China. So I think all these actions, like the anti-national agitation movement, the Occupy Central movement, and the anti-extradition movement were counterproductive in the sense that they were the protesters wanted to get more freedom or more democracy, but in the end they will get even less than what they already had. So this is a kind of tragic situation which Hong Kong people, or those Hong Kong people who cannot emigrate, will have to face and to think about.
Thank you. Professor Cheng, yes, go ahead.
Is it unmuted?
Yes, yeah, go ahead.
Just as a prediction, I think there will probably be sort of a spectrum of the chilling effect. The most clear one will be against foreign engagement of Hong Kong's political activities. That seems to be the most clear signals from the law, and that's also why I think it's also consistent with my observation of a identity politics battle, because China doesn't mind that Hong Kongers become more marginalized, but they're afraid that Hong Kong will be more westernized. So it's kind of a de-Chinese. And the second chilling effect will be more or less on hate speech, because it's very vague, right? Which can be considered as incitement of secession, for example, or what can be considered as subversion. If you criticize the leadership, for example, is it incitement or subversion, or is it just hate speech, or is it some kind of freedom of expression? And finally, I do think that Hong Kong people should insist that the law be enforced by Hong Kong judiciary and Hong Kong government, even if the Chinese security agencies will have a branch in Hong Kong upon the necessity, right? If needed, the a draft says if needed. So if it's not needed, if it's able to be enforced by the Hong Kong judiciary and Hong Kong law enforcement, then it will not be needed to deploy any security agency in Hong Kong. That's my personal view.
Thank you. Professor Potter?
Thank you. Well, as you say, we don't really know till it happens, but I think if someone were to ask me what would be the status the day after it's enacted, I would say virtually none. These things happen gradually, but it's that drip, drip, drip effect of constraining freedom of expression. So I think Professor Chen just put it really, really well, which is to say, when one criticizes a leader, is that subversion, is that incitement, or is that just freedom of expression? And we don't know. But when a expansive interpretation of national security, such as exists in China's national security law, and expansive definitions of state secrets, as in Chinese state secrets law, start having echoes in China's drafting laws for other areas, such as Hong Kong, I think it's worth asking the question about what that drip, drip, drip relies on. I think, there are authoritarian regimes throughout Chinese history, throughout European and global history. And often authoritarian regimes enact measures that keep them in power. And often those measures initially are greeted with a yawn. They're not seen as that important. But then over time, selective people are punished. Lessons are given to the rest of the society. It's the, and so I think it really does lead to a potentially slippery slope. And this touches on the point I made earlier, which is about the rule of law. The rule of law affects the process. What will be the process for truly independent thought on what a particular provision in the forthcoming law means? And then also it affects substance, the red line. Where is the red line? Where is it? It may be one place today, maybe one place tomorrow. Those are substantive issues, and our confidence that they will be handled justly and fairly, as with procedural issues, ultimately boils back down to the question about the rule of law. Now, I would just say one last thing about this. An economist in China once told me that a market economy is an information economy. And that is something that I think is worth taking note of and expanding on. So frankly, it is not in the interest of the state to constrain opinion. And the reason for that is that no matter how much meritocracy there might be, as some would argue, people make mistakes. People have limited amount of information. They have bounded rationality in Bourdieu's terms. And so more people involved in a process of thought and discussion is better. And it actually will help the state to provide the prosperity and the safety and the security that people need. So to reserve those decisions to an unaccountable small group, relatively small group of people that are not accountable to law or really to anything else, ultimately will hurt the state because it will deprive them of the variety of ideas that are the foundation for being able to respond effectively to the crises that we face today and will continue to face in the future. Thank you.
I'm mindful that we have about 6 minutes. I do want to slip in one last question for everyone, which is about the state of health of one country, two systems, as you see it at this moment. Perhaps can we start with Professor Chen, because that was the talk that we were going to invite you to come to UBC back in March. One country, two systems. So I do want to circle back to this. What is your thought on the state of health of one country, two systems as it is? You're muted, Professor Chen. Yes.
In 2017, when we celebrated the 20th anniversary of the Hong Kong SAR, I think that the mood at that time was quite good generally. President Xi Jinping came and gave a speech, and there were no radical protests against him. And so nobody could have expected that in 2019, all that we saw last year could have happened. So I think there's quite a lot of historical contingency in this matter. Personally, I believe that if there were no Chen Tong Kai incident that is his murder committed in Taiwan, there would not have been the extradition bill, and there would not have been the protests. But of course, as Professor Porter just said, the protests actually were evidence or expression of pent-up frustration. So it is indeed, there has been pent-up frustration building up over the years, mainly because of the failure of the realization of universal suffrage for the chief executive in 2017. So the Occupy Central movement, I think, was a very important factor. And many of the protesters who came up last year were already engaged in the Occupy Central movement. And the pro-Hong Kong independence movement was also, to a significant extent, a result of the failure to secure what the Pan Democrats called genuine universal suffrage in 2017. So I think 2019, what happened, revealed that one country, two systems was in a big crisis, in great trouble. So it's just like, you asked for a state of health. So one country system was certainly in very poor health. And Mr. Tung Chee-hwa, first chief executive, who said recently that, well, this national security law was a kind of medicine, okay, to cure the illness which we are facing. So I think the Chinese government does intend this to be the medicine. So we in Hong Kong are worried, and I understand the worries which Wilson just talked about, and also Pitman. So the worry is that this medicine will be too strong. So every kind of medicine has a side effect. So would the medicine be too strong? But there are maybe some hardliners in China who don't want the medicine to be too weak, so that it will not have any effect. So the question is, what will be the appropriate dose or the appropriate kind of medicine, which is neither too weak nor too strong? So I think that is the question.
Thank you. Professor Cheng, would you like to, do you have some thoughts on the state of health of one country, two systems?
Yeah. I think that the Hong Kong people should keep on asking. I'm very impressed by an article by Professor Deals of examining the discursive forms between Chris Patten and Zhong Jianhua. So he described kind of a political myth created by Patten, in the sense that it's not necessarily that there was a legacy of freedom or liberty and democracy before 1997. It was a narrative created, but it's an important narrative created, right? And if you read the biography by Zhong Shijie, who was the major participant of the Basic Law drafting, you will understand that all of the major provisions in the Basic Law that help Hong Kong to keep its high degree of autonomy comes from Hong Kong people. Article 8, Article 18, even Article 23, which authorize a region to make a national security law, which makes no sense, right? How come a region needs national security law? It should always be the sovereign power, right? But Article 3 actually provides a space for Hong Kong. And also Article 158. All of these were advocated by Hong Kong people who asked the central government to provide more autonomy and more space for Hong Kong to keep one country, two systems. So I do, you know, I I do believe there's a myth of liberty and democracy from the colonial rule. Instead, I believe that Hong Kong people should keep on asking, you know, like what's in the Bible, knock and the door will be open, right? If you don't ask, if you stopped the conversation, the dialogue, then it won't work.
Thank you. Professor Potter?
Thank you. I think it's useful to look at Hong Kong-China relations in the context of central regional relations in China historically. The central government has had long experience and frustration and changing policies on relations with the regions. And if you compare Deng Xiaoping with Jiang Zemin, Hu Jintao, you see an approach to relations with the regions that is somewhat conflicted, that that has red lines about what are national priorities, but what can be left to local and so on. I think under Xi Jinping, we have seen a more trend toward more centralization, but I think this is a policy issue that has gone back and forth. And this is where it's very interesting to, one of the names that has not come up today, Professor Wang Zhengming. Years ago, in 2002, I think it was, he published a very important book on the position of Hong Kong Special Administrative Region under China's constitution. And it talked about the constitutional provision that dispenses autonomy in different forms and made a specific comparison between special administrative regions like Hong Kong and national minority regions and autonomous counties and so on. And you know, Taiwan can be brought into this too, and I ended up doing a book about that topic. I think it was a very useful way of expressing what many scholars and policy people in China think, which is that if we say we're going to deal with the constitutional order in Hong Kong through the NPC decision in light of the Constitution, then we cannot avoid the discourse that Wang Zhengming brought to our attention, which is to say, look at the constitutional provisions on local autonomy. And there are many forms of those, but ultimately they're dependent on the Constitution. So in terms of going forward, I think that if we look at this as a process of evolving constitutionalism, there is potentially hope there because it ends up resting the arguments on, I know the Constitution, I've said, promotes party supremacy and so on, but if we rely on a constitutional text and its variations and formulation and interpretation, that gives us something that is relatively tangible, relatively consistent, relatively clear, that allows us to understand how this Hong Kong-China relationship in light of central regional relations in China. And it may, as I actually have said to people in Beijing and elsewhere, evolve from a situation where it's 一国两制 to one that is more like 一国多制, which is to say different regions have autonomy to have different arrangements. And Mao actually was quite cognizant of this, where when we looked at original land reform policies in Sichuan and Anhui, they couldn't have been driven by the center. There's no way they could be driven by the center. They had to be tested locally, and when they were tested under Zhaoziang, for example, in Sichuan, they had great success and then were molded into national policy. So that space between the central government and regional governments is an important area of constitutional deliberation and I would say a contested domain of constitutional deliberation, but one that could be extremely fruitful in thinking about what would be the future of one country, two systems.
Thank you. And I'll leave the last word to Mr. Leung.
Thank you. In my view, one country, two systems is terminally ill. And the worst thing about it is that there's a misdiagnosis by Beijing as to the cause of this illness. Is blamed on foreign interference / separatism / terrorism. When reality, what the people here really want is just more representation as guaranteed to them under the basic law. And because of this misdiagnosis, unfortunately, it's the wrong medicine that's being applied. It's not a question of whether it's strong or weak medicine, it's the wrong medicine for the illness, which unfortunately will probably kill the patient. I see a quote from Canada's newspaper, The Star, last week. So one economist, Rory Green, said, one of the big attractions for businesses is that Hong Kong is essentially China without the CCP in the last 20 years. So basically what it means is that Hong Kong is a place where Beijing doesn't do everything in the way it would do in the mainland. Hong Kong has its own space sometimes to act in a way that's different from what China would do in mainland China. But unfortunately, we're seeing that space being increasingly closed. The message now being sent to Hong Kong is that if you do not do things the way I would have done, e.g. enact national security legislation in the time frame and way I would have wanted, then I will do it for you. And that really is the end of anything that's an effective autonomy.
Thank you, Mr. Leung. I'm mindful of time, and thank you very much for all the panelists for joining us today. Thank you for all the audience from around the world joining us today. This is, of course, a topic of great concern and interest, and we'll continue to pay attention to Hong Kong. I think even though we do have different opinions, but I can clearly see sort of a commonality between all of us here today, which is we are deeply concerned and interested in the well-being of Hong Kong. So I hope the conversation will continue, and of course, all the best for Hong Kong and the rest of the world. Thank you very much. And on that note, this comes to a close. Thank you very much.